In daily life, many of the advocates and many of the students and activists are getting some doubts about writs and their scope. Means which topics or which cases can be considered as writs and what are writs and what is the scope of writs, like that. There are many questions are arising in the daily life. So when we are going to know about the writs and their scope, under the Indian legal system, jurisdiction to issue prerogative writs is given to the Supreme Court and to the High Courts of Judicature of all Indian states. Parts of the law relating to writs are set forth in the Constitution of India. The Supreme Court, the highest in the country, may issue writs under Article 32 of the Constitution for enforcement of fundamental rights and under Article 139 for enforcement of rights other than fundamental rights. While High Courts, the superior courts of the states, may issue writs under Article 226. The Constitution broadly provides for 5 kinds of prerogative writs. Those are habeas corpus, certiorari, mandamus, quo warranto and prohibition. These are the 5 writs. So the first one is habeas corpus. What is meant by habeas corpus? A writ of habeas corpus is in the nature of an order calling upon the person who has detained another to produce the latter before the court in order to let the court know on what ground he has been confined and to set him free if there is no legal justification for the imprisonment. The words habeas corpus literally mean to have a body. By this writ, therefore, the court secures the body of a person who has been imprisoned to be brought before itself to obtain knowledge of the reason why he has been imprisoned and to set him free if there is no lawful justification for the imprisonment. The writ may be addressed to any person whatever, an official or a private person who has another person in his custody, and disobedience to the writ is met with punishment for contempt of court. The writ of habeas corpus is thus a very powerful safeguard to the subject against arbitrary acts not only of private individuals but also of the executive. Habeas corpus petition becomes infractious if the detainee is produced before the magistrate. The different purposes for which the writ of habeas corpus is available may accordingly be stated as: first one, for the enforcement of fundamental rights. It has already been explained that under our Constitution, the right of personal liberty is guaranteed against the state by Article 21, which says that no person shall be deprived of his life or personal liberty except according to procedure established by law. Hence, if the executive has arrested and detained any person without the authority of any law or in contravention of the procedure established by the law which authorizes the detention, or the law which authorizes the imprisonment is itself invalid or unconstitutional, the High Court or the Supreme Court may issue a writ of habeas corpus against the authority which has kept the person in custody and order the release of the person under detention. However, it will also issue where the order of the imprisonment or detention is ultra-vires the statute which authorizes the imprisonment or detention. The writ of habeas corpus is, however, not issued in the matters. Those are where the person against whom the writ is issued or the person who is detained is not within the jurisdiction of the court. And second one, to secure the release of a person who has been imprisoned by a court of law on a criminal charge. And third one, to interfere with a proceeding for contempt by a court of record or by parliament. Two means actually Supreme Court has given detailed guidelines and detailed definition about this habeas corpus in the case of Sunil Batra versus Delhi administration and P.S. Sadasiv Swamy versus State of Tamil Nadu. Now the second one, certiorari. Briefly speaking, therefore, while prohibition is available at an earlier stage, certiorari is available at a later stage on similar grounds. The object of both is to secure that the jurisdiction of an interfair court or tribunal is properly exercised and that it does not usurp the jurisdiction which it does not possess. The conditions necessary for the issue of writ of certiorari are: there should be a tribunal or officer having legal authority to determine questions affecting rights of subjects and having a duty to act judicially. Such a tribunal or officer must have acted without jurisdiction or in excess of the legal authority vested in such quasi-judicial authority or in contravention of the rules of natural justice, or there is an error apparent on the face of its record. And the Supreme Court earlier took the view that the writ of certiorari would not issue against purely administrative action. It would issue only if the authority has a duty to proceed judicially, that is to say, to come to a decision after hearing the parties interested in the matter and without reference to any extraneous consideration. But later, decisions have obliterated the distinction between administrative and quasi-judicial bodies. The current view is that even if the governing statute does not require that before making an order affecting the individual, he must be heard, such a requirement would be implied by the court where the right of property or some other civil right of the individual is affected. To omit to do this is to deny natural justice, and in such cases the court may quash the so-called administrative decision by means of a writ of certiorari under Article 226. A tribunal may be said to act without jurisdiction in any of the circumstances, such as where the court is not properly constituted, that is to say, where persons who are not qualified to sit on the tribunal have sat on it and pronounced the decision complained against. However, where the subject matter of inquiry is beyond the scope of the tribunal according to the law which created it, where the court has assumed a jurisdiction on the basis of a wrong decision of facts upon the existence of which the jurisdiction of the tribunal depends, where there has been a failure of justice either because of the tribunal has violated the principles of natural justice or because of its decision has been obtained by fraud, collusion or corruption. And also, when the decision of an interfair tribunal is vitiated by an error apparent on the face of the record, it is liable to be quashed by certiorari, even though the court may have acted within its jurisdiction. Error in this context means error of law, where the tribunal states on the face of the order the grounds on which they made it, and it appears that in law those grounds were not such as to warrant the decision to which they had come. Certiorari would issue to quash the decision. In all such cases, a high court can issue a writ of certiorari to quash the decision of the interfair tribunal, and the Supreme Court can also issue the writ in such a cases, provided some fundamental rights has also been infringed by the order complained against. Supreme Court has given detailed notes and also detailed definition to this writ of certiorari in the case of State of UP versus Muhammad Noor, and also in the case of Hari Vishnu Kamath versus Ahmad Ishaq. Now, the third one is writ of mandamus. Mandamus literally means a command. It demands some activity on the part of the body or person to whom it is addressed. In short, it commands the person to whom it is addressed to perform some public or quasi-public legal duty which he has refused to perform, and the performance of which cannot be enforced by any other adequate legal remedy. It is therefore clear that mandamus will not issue unless the applicant has a legal right to the performance of legal duty of a public nature, and the party against whom the writ is sought is bound to perform that duty. It is discretionary remedy, and the High Court may refuse to grant mandamus where there is an alternative remedy for redress of the injury complained of. In the matter of enforcement of fundamental rights, however, the question of alternative remedy does not weigh so much with the court, since it is the duty of the Supreme Court or High Court to enforce the fundamental rights. In India, mandamus will lie not only against officers and other persons who are bound to be a public duty, but also against the government itself for Article 226 and Article 321, provided that appropriate proceedings may be brought against the government concerned. The writ is also available against interfair courts or other judicial bodies when they have refused to exercise their jurisdiction and thus to perform their duty. The purposes for which a writ may be issued may now be analyzed as: for the enforcement of fundamental rights, whenever a public officer or a government has done some act which violates the fundamental right of a person, the court would issue a writ of mandamus restraining the public officer or the government from enforcing that order or doing that act against the person whose fundamental right has been infringed. Thus, where the petitioner who was otherwise eligible for appointment to the subordinate civil judicial service was not selected owing to the operation of a communal rotation order which infringed the fundamental right guaranteed to the petitioner by Article 16(1), the court issued an order directing the state of Madras to consider and dispose of the petitioner's application for the post after taking it on the file on its merits and without applying the rule of communal rotation. And the other one, apart from the enforcement of fundamental rights, mandamus is available from a high court for various other purposes, that is, to enforce the performance of a statutory duty where a public officer has got a power confirmed by the constitution or a statute. The court may issue mandamus directing him to exercise the power in case he refuses to do it. And second one, the writ will also lie to compel any person to perform his public duty where the duty is imposed by the constitution or a statute or a statutory instrument. To compel a court or judicial tribunal to exercise its jurisdiction when it has refused to exercise it. However, to direct a public official or the government not to enforce a law which is unconstitutional, mandamus will not be granted against the persons. Those are the president or the governor of a state for the exercise and performance of the powers and duties of his office or for any act done or purporting to be done by him in the exercise and performance of those powers and duties under Article 361. However, mandamus does not lie against a private individual or body, whether incorporated or not, except where the state is in collision with such private party in the matter of contravention of any provision of the constitution or a statute or a statutory instrument. The Honorable Supreme Court explained well about the writ of mandamus and its definition in the case of Mani Sobraj Jain versus State of Haryana. However, the fourth one is quo warranto. Quo warranto is a proceeding whereby the court inquires into the legality of the claim which a party asserts to a public office and to oust him from its enjoyment if the claim be not well founded. The conditions necessary for the issue of a writ of quo warranto are: first one, the office must be public and it must be created by a statute or the constitution itself. Second one, the office must be a substantive one and not merely the function or employment of a servant at the will and during the pleasure of another. And third one, there has been a contravention of the constitution or a statute or a statutory instrument in appointing such person to that office. The fundamental basis of the proceeding of quo warranto is that the public has an interest to see that an unlawful claimant does not usurp a public office. It is, however, a discretionary remedy which the court may grant or refuse according to the facts and circumstances of each case. A writ of quo warranto may thus be refused whether it is vexatious or whether it would be futile in its result or whether the petitioner is guilty of laches or whether there is an alternative remedy for ousting the usurper. Where the application challenges the validity of an appointment to a public office, it is maintainable at the instant of any person, whether any fundamental or other legal right of such person has been infringed or not. Quo warranto is thus a very powerful instrument for safeguarding against the usurpation of public officers. Honorable Supreme Court explained about the quo warranto in the case of University of Mysore versus DVRao. And now the fifth one is writ of prohibition. The writ of prohibition is a writ issued by the Supreme Court or High Court to an interfere court forbidding the latter to continue proceedings therein in excess of its jurisdiction or to usurp a jurisdiction which it is not legally vested. In other words, the object of the writ is to compel interfere courts to keep themselves within the limits of their jurisdiction. The writ of prohibition differs from the writ of mandamus in that while mandamus commands actively, prohibition commands inactively. Further, while mandamus is available not only against the judicial authorities but also against the administrative authorities, prohibition as well as certiorari are issued only against judicial or quasi-judicial authorities. Hence, prohibition is not available against a public officer who is not vested with the judicial functions. Where excess of jurisdiction is apparent on the face of the proceedings, a writ of prohibition is not a matter of discretion but may be had of right. In India, a writ of prohibition may be issued not only in cases of absence or excess of jurisdiction but also in cases where the court or tribunals assumes jurisdiction under a law which itself contravenes some fundamental right guaranteed by the Constitution. The Supreme Court can issue the writ only where a fundamental right is affected by a reason of the jurisdictional defects in the proceedings. Thus, prohibition and certiorari are both issued against courts or tribunals exercising judicial or quasi-judicial powers. Certiorari is issued to quash the order or decision of the tribunal, while prohibition is issued to prohibit the tribunal from making the ultra-virus order or decision. It follows, therefore, that while prohibition is available during the pendency of the proceedings and before the order is made, certiorari can be issued only after the order has been passed. Honorable Supreme Court has given detailed note on this prohibition in the case of Govind Menon versus Union of India. So, here it is very clear that writs are 5 kinds. Those are habeas corpus and writ of certiorari and writ of mandamus and writ of quo warranto and writ of prohibition. And the case Sunil Bhatra versus Delhi Administration and the case P.S. Sadashiv Swami versus State of Tamil Nadu explained well about the habeas corpus, and the case State of Uttar Pradesh versus Muhammad Noor and the case Hari Vishnu Kamath versus Ahmad Ishaq explains briefly and the guidelines of the Supreme Court about the cases of certiorari. However, the case Mani Sobra Jain versus State of Haryana explains well about the writ of mandamus. However, the case University of Mysore versus DVRao explains about the writ of quo warranto. Similarly, the case Govind Menon versus Union of India explains well about the writ of prohibition.